Tonight, we begin with a legislative development that immigration attorneys had feared, advocacy groups had dismissed, and millions of green card holders had never prepared for. A policy shift that unfolded not over months of debate, but in 72 hours. 72 hours that rewrote decades of immigration precedent. 72 hours that placed 9 million lawful permanent residents under new scrutiny. 72 hours that fundamentally changed what it means to hold a green card in America. What Congress approved this week crossed a line that immigrant rights organizations had hoped would hold. And when that line broke, the Department of Homeland Security did not hesitate. They responded with efficiency, with precision, and with a sweeping enforcement mechanism that begins March 1, 2026. For 18 months now, there had been signals. Not from official press releases, not from formal committee hearings, just signals that hardliners in Congress were preparing something unprecedented. Congress has been restrictionist, yes, but they have been predictable in their restrictionism. Their moves have followed a certain rhythm, a pattern, almost a choreography. But what set off alarm bells in immigration law circles this January was that the rhythm went silent. Advocates who monitor legislative activity know the indicators. The leaked draft amendments, the closed-door bipartisan meetings, the sudden withdrawal of moderate Republican opposition, the abrupt postponement of scheduled immigration hearings. All of that went quiet, and whenever Congress goes quiet on immigration, it means something is about to get loud. For months, policy experts noticed something unusual. Senior Democrats who had historically defended permanent residency protections began using carefully hedged language. They stopped saying, "Green card holders have earned the right to stay," and started saying, "Lawful permanent residents must continue to demonstrate their commitment to American values." That shift in language wasn't accidental. It was preparation. It was laying groundwork for what immigration attorneys are now calling the most significant change to legal permanent resident status since the Immigration and Nationality Act of 1952. Early Tuesday morning, the Senate Judiciary Committee detected what they described as broad bipartisan consensus on green card accountability measures, including procedural mechanisms that had not been invoked in immigration reform in over 4 decades. These are the kinds of legislative tools that Congress only deploys when they are signaling something very specific: a crisis requiring immediate action, a political realignment on immigration, or a fundamental redefinition of permanent residency itself. Observers didn't know which category this fell into, or whether it fell into all three at once. But what they did know was that Congress was changing its entire approach to legal immigration. And when lawmakers shift immigration strategy without extensive public debate, even by incremental measures, immigrant communities pay attention. The bill, officially titled the Legal Permanent Resident Accountability and Reaffirmation Act of 2026, does something that has never been done before. It creates a mandatory reaffirmation process for all green card holders every 5 years. Not just renewal, not just updating information. Reaffirmation, meaning green card holders must now actively prove their ongoing eligibility to remain permanent residents. This includes demonstrating continuous physical presence requirements, providing evidence of economic self-sufficiency, submitting to enhanced background checks, affirming loyalty to constitutional principles, documenting community integration metrics. The bill passed the Senate 64-36. It passed the House 247-188. The President signed it into law Thursday afternoon, and the implementation timeline begins in exactly 23 days. The guidance issued by U.S. Citizenship and Immigration Services tonight was not normal. It was not routine. It was not symbolic. It was urgent. Officials, after emergency implementation meetings, described the new law as administratively complex, legally unprecedented, and perhaps most importantly, retroactively applicable with limited exemptions. But legislative shock only works if the affected population hesitates. Immigration attorneys did not. In fact, their response today was among the most coordinated we've seen in modern immigration advocacy. Here's what we know. Within 6 hours of the president's signature, the American Immigration Lawyers Association issued emergency guidance to all 16,000 member attorneys. These weren't the standard policy updates. These were crisis protocols, communication strategies that immigration attorneys only deploy when they are preparing to handle mass confusion and potential deportation proceedings. The National Immigration Law Center filed an immediate federal lawsuit in the Northern District of California, arguing the law violates due process protections for lawful permanent residents. The ACLU announced it will file in 3 additional circuits by Monday, and legal aid organizations across all 50 states have activated emergency hotlines staffed by immigration specialists. But here's what makes the government's implementation plan so concerning. USCIS confirmed tonight that failure to complete the reaffirmation process within the mandated window results not in a fine, not in a warning, but in automatic revocation of permanent resident status. No hearing, no appeals process during the initial review. Just revocation, followed by the opportunity to contest the decision from outside the United States if the individual has already been removed. Tonight, Department of Homeland Security sources confirmed that USCIS will implement a phased rollout targeting specific green card holder categories, including long-term permanent residents who obtained their status before 2010. Individuals that analysts believe were specifically chosen because they are least likely to have maintained meticulous documentation for what the new law now requires. The government is processing reaffirmation applications before green card holders fully understand what documentation is required. They prioritized the elderly. They prioritized those who came as refugees decades ago. They prioritized those most likely to struggle with the sudden bureaucratic burden that requires evidence few immigrants thought to preserve. In other words, USCIS targeted the most vulnerable populations first. The individuals who may no longer have employment records from 15 years ago. This is what made immigrant advocates' warnings so urgent. Congress's legislative move wasn't just symbolic, it was actionable. It represented the kind of policy shift that could result in mass denaturalization if left unchallenged. And immigration attorneys, understanding that fully, responded with force. Not recklessly, not impulsively, but strategically. They didn't panic their clients. They didn't promise outcomes they couldn't guarantee. They issued clear guidance on documentation preservation. They established rapid response legal teams in every major metropolitan area. The American Immigration Council released a 47-page legal memorandum tonight analyzing every provision of the new law and identifying 14 distinct constitutional vulnerabilities. Catholic Legal Immigration Network mobilized its 400 affiliate organizations, and the National Partnership for New Americans activated its network across 40 states to begin community education sessions this weekend. And here's where the story becomes even more troubling. Legal scholars now believe that Congress's latest move was designed to test the constitutional limits of permanent residency after years of expansion in immigrant rights protections. Congress wanted to see whether immigrant communities would mobilize effectively, but instead, the opposite happened. Advocacy organizations didn't fragment into competing strategies. They unified around a coordinated legal and political response that was so swift, so comprehensive, that even congressional leadership noticed. You don't get the Senate Majority Leader's attention easily on an immigration bill after it's already passed. But today, immigrant advocates did. Constitutional law professors, speaking with news outlets under anonymity, described Congress's approach as stress testing, a way to identify how far permanent residency protections can be eroded before triggering sustained resistance. But immigrant communities prove today that they remain both organized and resilient. Their response was not only rapid, they coordinated so precisely that within 18 hours of the bill's signing, over 340,000 green card holders had already accessed legal resources, downloaded documentation checklists, and registered for community legal clinics. That mobilization matters because it shows something crucial. It shows that immigrant communities are not passive recipients of policy changes. They are active participants in defending their rights. The National Immigration Forum released data tonight showing that green card holders contribute $98 billion annually in federal taxes alone. They start businesses at higher rates than native-born Americans. They serve in the U.S. military. They are teachers, nurses, engineers, and small business owners. And they are now being told that their permanent residency was never actually permanent. As reports continued coming in throughout the evening, we learned more about the scale of the government's implementation plan. The Department of State will suspend visa renewals for green card holders abroad who have not completed reaffirmation, forcing tens of thousands to return to the United States immediately or risk status loss. ICE field offices have been instructed to prioritize enforcement actions against individuals whose reaffirmation applications have been denied in the last 6 months. USCIS processing centers, already facing backlogs of 4.8 million cases, will now handle an estimated 9 million reaffirmation applications over the next 3 years. This wasn't just administrative reform. This wasn't just enhanced vetting. This was systemic restructuring. This was bureaucratic overwhelm by design. And bureaucratic overwhelm is the one thing immigrant communities have struggled to overcome since the Trump administration's maximum enforcement era. For every protection they have secured through litigation, the government has countered with something that creates new procedural barriers. Remember, Congress thought immigrant advocacy organizations were fragmented. They thought legal challenges would take months to materialize. They thought green card holders would comply quietly. But tonight, the exact opposite is happening. 23 civil rights organizations filed coordinated amicus briefs within hours. Immigration law clinics at 67 universities activated emergency student attorney programs, and over 1,200 private immigration attorneys pledged pro bono hours through the new Green Card Defense Project. What makes this moment so critical and so dangerous is that Congress's latest move happened at a time when the administration is under enormous political pressure. Progressive Democrats want full amnesty for undocumented immigrants. Moderate Democrats want a balanced approach that protects legal immigration while addressing border security. Republicans want merit-based immigration reform. Immigration hardliners want categorical reductions in all immigration pathways. The president is balancing these demands while facing a contentious election year. And when leaders in that position make sudden moves, they're not doing it from strength. They're doing it from pressure. They're doing it from vulnerability. This law passed because both parties found something they wanted in it. Democrats secured language protecting dreamers from inclusion in reaffirmation requirements. Republicans secured the 5-year review mechanism they've sought for decades. And green card holders, the 9 million lawful permanent residents who followed every rule, paid every fee, and waited every mandated period, became the compromise. The Department of Homeland Security's implementation memo, now distributed to all field offices, was designed to signal that the administration is not willing to delay enforcement of the new congressional mandate. Officials said plainly that green card holders' failure to complete reaffirmation was inconsistent with maintaining lawful permanent resident status. That is bureaucratic language for, your green card means nothing if you don't jump through these new hoops. You don't usually hear that tone from DHS unless something serious is at stake. And what's at stake is simple: the redefinition of what permanent means in permanent residency. Meanwhile, the executive director of the National Immigration Law Center addressed the media in a forceful, uncompromising speech tonight. She said, "For generations, America told immigrants that if you follow the rules, if you build your life here legally, you will be secure." She said, "Tonight, Congress broke that promise." And she said, "But we will not let this stand unchallenged. We will fight this in every court, in every community, and in every avenue available until permanent residency means what it has always meant: permanent." These are not rhetorical flourishes. These are statements from an advocacy community that understands just how high the stakes have become. Here's what makes the situation even more concerning. Congress's latest move wasn't isolated. Along with the reaffirmation requirement, the State Department also announced accelerated visa interview requirements for family-sponsored immigration petitions. USCIS increased filing fees for naturalization applications by 83%. ICE expanded collaboration agreements with local law enforcement agencies in 23 new jurisdictions. All of this happened within the same 2-week period. When Congress moves multiple immigration enforcement pieces at once, it means something larger is underway. This isn't reactive policymaking. This is coordinated strategy. Immigration policy analysts are now considering several possibilities. One is that Congress is preparing comprehensive immigration reform legislation and using this law to establish negotiating leverage. Another is that Congress is attempting to reduce overall immigration numbers without the political cost of cutting visa allocations. A third possibility, the one worrying advocates the most, is that Congress is attempting to create a permanent underclass of provisional residents who never achieve true security. But today, immigrant communities took that card off the table. They didn't wait for court rulings. They didn't hope for executive branch discretion. They didn't rely on congressional reconsideration. They mobilized, legally, strategically, and immediately. What we're watching now is a test of resilience. Congress wants to see whether permanent residents will accept diminished status. Immigrant advocates want to show that legal protections still have meaning. The courts want to prevent constitutional violations. And affected families want to prevent their lives from being destroyed by bureaucratic mechanisms they cannot control. Tonight, we've heard from immigration attorneys who are now scheduling emergency consultations 7 days a week. They say demand has increased 340% since Tuesday. They say many green card holders are considering naturalization applications immediately, despite the increased costs. And they say Congress's decision to implement retroactive requirements is likely part of a broader enforcement strategy intended to identify and remove individuals with any immigration history irregularities, no matter how minor. But immigrant communities are not panicking. In fact, immigrant communities are organizing. Their response today, coordinated, strategic, and comprehensive, sent a message to Congress that this will not be accepted quietly, and it sent a message to DHS that every regulatory decision will be scrutinized, challenged, and litigated if necessary. As the coming weeks unfold, we expect more details to emerge about what exactly Congress hoped to achieve. But what we do know is that the immigrant rights community's response was timely. It prevented mass confusion from becoming mass panic. It provided clear legal guidance when government communications were deliberately vague. And it demonstrated that lawful permanent residents will not accept the erosion of their status without a fight. What happens next will depend on what the courts do in the next 60 days. If they grant preliminary injunctions, this moment will be remembered as congressional overreach stopped by constitutional guardrails. If they allow implementation to proceed, immigrant advocates have already shown they are prepared. They have shown they are ready to respond. And tonight, for the first time in decades, green card holders appear to be questioning the meaning of permanent. Immigration law firms are overwhelmed. Community centers are packed. And when 9 million people simultaneously realize their security was always conditional, it means they are recalculating their futures. It means they are choosing their next steps carefully. Because tonight, lawful permanent residents learned something many have suspected but never wanted to believe. Permanent doesn't mean forever. Security can be legislated away in 72 hours. And the only protection that matters is the one you're willing to defend. This story is far from over. But tonight, one thing is clear. The definition of permanent residency in America has changed. The fight to restore its meaning has just begun. And millions of families are now watching to see whether the promise of legal immigration still holds. And we will be here, watching every detail as the next phase unfolds.